I'll bet you didn't know August is National Make a Will Month. We hope you enjoy our presentation on wills and trust documents because, as we know, no one enjoys talking about inevitable decisions. I mean, let's be honest. It's kind of tacky to sit down for Thanksgiving dinner and say, "Hey, Mom, great turkey. Did Dad and you finish your wills?" Not the best conversation you want for Thanksgiving dinner. We all think that we have all the time in the world. But how many of us have had friends or family who were faced with an unexpected situation of having an incapacitated loved one or losing a loved one? Suddenly, there are decisions to be made, and the family is ill prepared to make them. They need an estate plan. Joining me today is my partner, Shawn McCabe. Together, he and I will strive to help you make some sense of the estate planning issues and processes. Shawn, help us out.
Thanks, Marshall. Yep, it's a subject that most folks don't want to talk about or don't know how to talk about it. Hopefully, like you said, we're here to help with those conversations or at least plant some seeds and give some ideas. So, as the slide says, I always like to start out with a public service announcement. And Marshall, you always pick on me about my statistics, so we're not going to go deep in statistics today. But I want to say about half of Americans do not have any formal arrangements made in the event of their untimely death or incapacitation, as you said. What this means is, especially for us Floridians, the Florida statute and the Florida court system will have to intervene if you do not have your affairs in order. I'd say most people think estate planning is associated with end of life planning. While that's a big part of it, there's so much more that needs to be considered long before death that most people never even think about. With that, and in observance of Make a Will Month and our passion for helping our clients, we are here today to shed some light on the subject and hopefully get everyone listening to begin some sort of estate planning. We'll run everyone through kind of how we think about it, how a CPA financial planner's perspective on what financial planning and estate planning is, and what typically is covered at a high level, and when and why estate planning matters. And of course, the OB3, as I've learned, the new nickname for the One Big Beautiful Bill, has made a few changes. So we'll like to cover that today. But first, our lawyers told us to tell you we are not lawyers. We are tax professionals, of course, CPAs and financial planners. We do help our clients navigate the complexities of their financial and tax scenarios, which routinely includes their estate plan, most of the time, actually. With that being said, our presentation today is to help educate you, motivate you to start planning, and point you in the right direction for legal counsel when you begin the process of drafting your documents. We do have resources and access to a highly competent network of attorneys who would love nothing more than to jump in and help us plan. So, okay, Marshall, now that that's out of the way, let's get down to business.
Sounds good, Shawn. Basically, we talk about the four documents you should not leave home without, more important than that American Express card. And there's one you most likely want to have. As you can see from the screen, we're going to talk about healthcare surrogates for medical decisions, durable power of attorneys, uh, handles affairs when you're incapacitated, living will for end of life decisions. That's a real misnomer. The last will and testament, talking about assets and guardians, and the living trust, how to rule from the grave, or creditor protection, estate planning, privacy, no probate, lots of options in there. Well, many investors don't realize that assets in different types of accounts, including retirement accounts, such as IRAs, 401ks, Roth IRAs, savings and investments, will pass to named beneficiaries if they're named on those accounts. And that named beneficiary will supersede whatever you might have thrown into the will or documents. When you set up those accounts, you have to be careful. So I always ask the question with clients, when was the last time you reviewed your beneficiaries? True story. We had a client pass away. He'd been with the same employer for decades. He'd been divorced and remarried, but never got around to changing the beneficiary from his ex-wife to his current wife. Oops. Good thing he was dead because someone would have killed him. Other ways that assets may pass are joint ownership, often usually with the spouse or with a child, or through a trust. Think of it as two phases. The first phase is the living side of the legal documents, and the second phase is the you're dead side of the legal documents. The living side, there are three documents: the healthcare surrogacy, the durable power of attorney, and the living will. The healthcare surrogacy trusts a person to make medical decisions. We'll go into more depth on each of these. The durable power of attorney grants some trusted person the ability to handle your legal and financial affairs should you become incapacitated. And the living will states your end of life care. If you do not have a living will, doctors, of course, will do everything necessary to help keep you alive. The truth is, death and incompetence just don't have a defined age. Planning and having the talk earlier rather than later will help your loved ones avoid the stress and indecisiveness that comes with those inevitable times. Being prepared is the best gift that you can give your family. Enter phase two, the death side of the legal documents. This is where your will and trust come into play. This is basically what I want you to do and my stuff. That's the will. The trust generally gives the instructions of how to do it, helps avoid probate, and we'll talk more about each of these during the presentation. Now, we'll start with the healthcare surrogates. Now, here's where you need someone you really trust. Think about this. You're sick, you can't make health decisions. The doctor's recommended a test or procedure. Who decides whether or not to proceed? Who do you want to make those decisions? Now, let's be honest, usually it's your spouse, but let's say you were both in an accident and your spouse is in the same situation. Who makes the decision? Invariably, we see families divided immediately into two camps. Camp one is let's do CPR on dad's corpse. And camp two is unplugging the life support to charge their cell phone. Which camp do you want carrying out your wishes? Maybe you don't care, but I think most people we meet do, and they want to be able to make those decisions. Well, like the healthcare surrogacy, who makes financial decisions when you can't? Again, usually this is your spouse as the first backup, but who's the next decision maker up in line? Is that person geographically located to provide ongoing support? Is that person knowledgeable enough to handle your affairs? Can they negotiate the sale of my business or real estate? Who will manage my investments? Who's filing my tax returns? Lots of things to consider. Does this person have the skill set, or is it simply birth order? It's the oldest child. We see this challenge a lot with clients, and it's not easy. But having that trusted person to be the durable power of attorney or have the durable power of attorney is critical in doing your planning.
So, Marshall, you're talking about the living will as part of the four main documents, the trust being the fifth potential document for most clients. And it's something that a lot of people don't do and don't talk about. Because again, a lot of time people are thinking about end of life planning. So for the next couple of slides, for those who are listening, we're going to dive a little bit deeper in each one of those sections, kind of explaining how these play and so maybe some cases that we've come across or you may even know about to kind of drive this point home. Marshall, you referred to living will. It's sometimes also referred to as an advance directive. Like you mentioned, it states your wishes for end of life care. If you don't have a living will, like you said again, Marshall, doctors will do anything necessary to keep you alive. And this is one of the messier areas of estate planning on families when no living will is present. Case in point, many of you may remember the Terry Schiavo case. The Terry Schiavo case was a series of court and legislative actions over a 7-year period regarding the care of Terry, who was in irreversible permanent vegetative state. In short, Terry and her husband were young, didn't think anything would happen to them, and did not have a living will or any of the other estate planning documents in place. Her husband, for Terry's sake, after several months, wanted to pull the plug and let Terry rest in peace. But her parents sued to prolong her life, and that battle persisted over 7 years. 7 years in the permanent vegetative, or I guess they say persistent vegetative state. Ultimately, that case finally ended after a 7-year period. Mr. Schiavo was able to lay his wife to rest. But that landmark case is an irrefutable example of the importance of outlining how you want to be treated in the event you are ever in that situation. The quickest way to the quickest way to tear a family apart when they should be coming together is forcing siblings to make decisions like that. And Marshall, I love your joke about let's unplug that. We got to charge our cell phones, or hey, let's just keep going, right? So it really is a huge relief on families to just have it in writing what you would want to happen in the case you got put in that situation.
It's just not an easy, it's not an easy time, and the emotions are there, and somebody's got to be in charge and make those hard decisions. And it's better that you get to pick them out than, okay, let's draw for short straws to who decides how to take care of dad.
Absolutely. And, and it's not just about, me, right? Of course, I don't want to put my kids in that situation. And knowing this, I'm a huge advocate, of course, for this, but I've gotten with my parents and said, Mom, you absolutely have to do this. How do you want us to handle any situation that comes up? And we talked about it and put those documents in place for her. So, if you're listening to this, please, it's for everybody, not just you.
It's a guarantee, as they would say.
Death and taxes, right?
Yeah.
Uh, so moving on to, we talked about the living will, which is sometimes confused because the word will is in both of those. So you have the living will and then the last will and testament, right? And the living will is usually referred to maybe as an advance directive, right? And to some hospitals will refer to it that. The last will and testament is what most people think of when they hear the word will. So in that case, we're going to spell this out a little bit. The will is a legal document that communicates a person's final wishes regarding both dependents and possessions upon their death. Some people forget about that. Like, hey, where we want our stuff to go? And ultimately, if you have underage kids, who's going to take care of the kids? That's what this instrument can be used for. The will names an executor or a personal representative of the estate who is responsible for administering the estate. And you may also name a separate person as a guardian for your children. In some cases, the person you want raising your children may not be so good with money and vice versa. So you've got to be thinking about these things. And you would do that in a will. Um, in a will, and thinking about how kind of estates are structured, assets that pass through a will or are directed to pass to the beneficiaries by the will must go through a court process known as probate. Many of you may have heard of that. In probate is administered by the executor. So the executor gets put in charge of what the will says and then just kind of guides and makes sure the assets get out to the beneficiaries accordingly. That role as the executor can be demanding. So you need to be really smart with who you select on handling your estate. Usually somebody with some financial knowledge or business or legal knowledge usually helps there. Again, so carefully consider who that choice is. And same thing for the guardianship, right? You may have somebody who's really sharp in finance, but has never been around kids. Do you want crazy Uncle John who's really good in finance raising your kids? Maybe not. But you want to be able to put that in these documents. And it's something else that's usually included with the will. It's not binding, but it's extremely helpful to also give instructions to your executor, just a written letter that's part of the will package, and kind of just helps the substance of what the person who is writing the will is trying to portray. So sometimes you'll see those letters involved there. And we always want to talk about this, like I mentioned earlier, about my wild statistics of about half of Americans do not have any sort of estate planning at all, including a will. So if you die without a will, it's known as dying as intestate, which means your spouse and your family could lose control of the process and the courts could take over. So if there's a conflict, your spouse and your parents, kind of in that Terry Schiavo case, without a written document that you've signed dictating your wishes, the courts may get involved. So again, you don't want to die intestate. That means the courts take over. This can complicate matters even for your current spouse if there are children from prior marriages. So it gets even more muddy. So it's just one example of many. And having situations like that can prevent the estate from being distributed and drag it out for years and cost a lot of money that was unnecessary. In just short, please just get a will done. Having a written and properly executed will guides the probate process and ensures your final wishes of your assets and your children are honored. Pretty straightforward. The last piece in kind of end of life planning, if you will, is the trust. And there's some confusion out there on trust. Like, when do I need to have one? Should I have one? When don't I need one? But I really want to just start with the basics. And there are many types of trust out there. Depending on their design, those trusts serve a very, very specific purpose. Some are just more broad and serve a broader purpose. But the most common trust that we see is known as a living trust, also referred to as inter vivos trust, which simply means it was made during one's lifetime. In the simplest of forms or terms, or the easiest way to explain this without getting too complex about it, a trust or the living trust is a document, essentially, that allows a grantor, you, somebody who's giving items to the trust, eventually to the beneficiaries, to retitle your assets in the name of the trust. And that allows those assets to be managed by somebody else, known as a trustee, for the benefit of a beneficiary. I said a lot there. This is recorded, so rewind that and listen to it as many times as you want. But it's different than a will because assets are actually owned by the trust. And that's the key difference here. The will just says, hey, I want my stuff to go here. The executor files the will and gets your stuff out to the beneficiaries. In a trust, all your assets will be named in the trust, and that trust will own those assets for a certain period of time. And in a future point, in whichever manner the grantor is assigned, those assets will be distributed, whether you take income off of it or the actual assets themselves will be distributed out in the future. We'll delve a little bit more into the practical uses of trusts, when and why in the next few slides. But I think it's worth mentioning now that there are really three primary reasons we see trusts. And Marshall, you mentioned on that slide a few seconds ago because we had it in the little highlights underneath. Number one is rule from the grave. And essentially, that means, hey, I don't want to give all of my assets to my 20-year-old son who, he's 20, he's legally able to own these assets, but he maybe just not mature enough yet. And so I want all my assets to go in here, and I want him to get it a little bit at 30 and the rest at 40. Well, that's what you would need a trust for. You're controlling what happens to your stuff after you pass. The second main reason is, in general terms, is avoiding probate. And you want to avoid probate. Not everybody has to avoid probate. It's not the end of the world if you go through probate, but it's a good way to get your assets passed on with efficiency, keeping costs down, and if you have privacy concerns. So avoiding probate. Probate's public. So if you want to pass your estate on privately, you'd want a trust to help do that. And then lastly, and lessly used, especially now that the OB3 is increased and made permanent, the estate tax exclusion amounts, trusts in general, irrevocable trusts, are good and can be used for estate tax planning purposes. And that's usually for larger estates. So let's put a pin in that for a few minutes and switch gears to discuss a few other topics. Marshall?
All right, Shawn, some of the things that you're thinking about in there, of course, would be have who's got the dependents, who ends up with the dependents, who takes care of the dependents. Maybe your letter of instruction that Shawn alluded to talks about whoever's going to be the guardian for the children. What are your thoughts? Do you want to pay for college? Do they get a new car when they turn 16? What are the thoughts down the road that aren't really legally binding in the will, but at least give a concept of what you're feeling? We're going to talk about large estates. Shawn's touched on it a little bit. We'll define a large estate and tell you some things that need to go in there. What if your family has a business? How do you wind that business down? Is that being passed on to the next generation? What are you thinking there? Charitable donations. Many people get charitable with part of their estate. Those are considerations. Health issues for various family members as well as the deceased. And of course, education for family members. So as you can see, part of the estate plan encompasses a lot of facets. It just isn't just about the last phase of your existence. Shawn, you want to share a couple of thoughts on these early ones?
Yeah, so I'll start by unpinning the trust conversation since we're diving into dependents first. Families with special needs children is a great example of the need for a trust, right? You may have situations that merit additional considerations, and you want a trust designed specifically for those situations. For example, assets left directly to a special needs child could potentially impact their continued qualification for public assistance programs. Instead, if you set up a special needs trust, you could raise the disabled child's standard of living without jeopardizing those need-based government benefits. That one gets a little complex when you're talking about planning because you have all kinds of other considerations in. You're not just considering, hey, not because little Johnny can't manage this, but there's other considerations involved from government programs, right? So you definitely want those trusts designed specifically for those circumstances. Another planning area regarding dependents relates to the healthcare power of attorney. Not just talking trust here, but estate planning in general. What do we do for dependents? That power of attorney is huge. For those dependents on kind of on our responsibility who are over 18, whether unmarried college students or aging parents, having them sign a healthcare power of attorney and HIPAA release are paramount. And I've been kind of on a mission lately to tell everybody about this, especially if those dependents rely on us for medical care in the event they become incapacitated. And the issue there, just briefly, is you've got an aged parent, and they're at the hospital, and whether they're incapacitated or not, the doctors are under no obligation to talk to you or share medical information with you unless you have those documents. So it's critical that if you're going to be involved in the healthcare of somebody else that's over 18, is to have these documents just to bypass any potential trouble. Marshall, you have anything to add to either one of these for the dependents?
No, I think we're good on that. It's just being careful to make sure that everybody's covered up.
Yep.
So, if it makes sense in your family circumstances, you may also want to consider passing assets during your lifetime. That can potentially reduce your taxable estate, allow the heirs to enjoy the benefits of your gifts sooner. You get to watch them enjoy it. And here's some options to consider. Probably the most popular that we go through with clients is direct gifting. For 2025, you can gift up to $19,000 each year to another individual without using part of your lifetime federal gift tax exclusion. Excuse me. That exclusion for 2025 is 13.99 million per person. So a married couple with two children and four grandchildren, let's use that. That's kind of like the traditional family setup. Could give $38,000, 19 from the husband, 19 from the wife, or 19 from dad, 19 from mom, however you want to look at it, to each of their children and grandchildren. That's $228,000. This would not reduce their lifetime exemption. Now, a bit of good news. Shawn's mentioned OB3, and we now have rules. Hey, great. We know what the rules are. We can actually plan. And so the lifetime exemption starting next year, 2026, is $30 million for a married couple. I'm sure most of you listening to this information wish this was a problem, but I can assure you, you don't wish it was a problem as much as your heirs wish it was a problem and we needed a plan. So there are a number of things that you can do in this area. If you have that large estate between the two of you, 30 million, get with us and we'll define some of those. But of course, for most Americans and for most people listening today, again, you wish that was a problem. So Shawn, help us out with businesses.
Businesses, man. There's a lot. There's a lot when it comes to businesses related to the estate plans. But I'm gonna hit it on let's do the top three, Marshall. And if I miss something, please jump in. The first thing I would say, you know, if you're a business owner and you have partners, is to have an operating agreement. That I can't tell you enough. That's another thing that at least in Florida, Florida state laws for partnerships is pretty straightforward. If you don't have an operating agreement, Florida state law takes over. So the agreement should include what happens to the business in the event of death or incapacitation of a partner. And I know a lot of partners who are thrilled at the idea of being in business with their partner's beneficiaries, say their spouse, when we've discussed this sort of planning with them. So this is the best place to use one of my favorite platitudes. If you fail to plan, you are planning to fail. So if you're a business owner and you have partners, just think about that. Like, what happens if one of us can't do this anymore? By operation of law, if you guys don't define it in your operating agreement, then your partner's interest could transfer to somebody you don't want to be in business with, and there is nothing you can do about it. So, operating agreements, number one. Number two, I would say consider what would happen if a key executive, maybe not one of your partners, maybe it is a partner, don't show up for work this morning because they died, right? Could your business continue to operate without them? We're not talking about the succession piece because we already did that. We're talking about the business itself. This is one of those areas where key man life insurance, not a recommendation, but just an idea, can come into play to ensure the business has funds to either replace that key person or give the company a little cash so they have time to pivot. Or in the case of an owner, maybe to pay out the partner's beneficiary, so you don't have to do it from the operations of or the the cash flow from the business operations. And that would be one of those things that you would have written in your operating agreement that the company buys the partner out, so it comes back to the company. And I would say the third thing for today, to keep it high level, is business owners should strive to have an overall business succession plan. Consider what happens if you, the sole owner of a business, forget the partnership for a second, gets hit by the proverbial bus. And I never want to see that bus, Marshall. I don't know about you.
Yeah,
Um,
no.
and a lot of times when I'm conversating, I'm like, if you hit the lottery and you decide not to come into work tomorrow, so we'll be positive here for a minute. But what happens to your staff, right? For a lot of us business owners, our staff's most important, followed closely by our clients. What happens to our clients and our customers who trusted us to follow through on the engagements that they're hiring us for? So who will take over those duties? Who will call the customers? And I've got a just quick side story here. Like in the Army, we would role play. In combat operations, you don't have time to think, you just have to do. So we would role play constantly during pre-combat exercises. Bang, Staff Sergeant McCabe, you're dead. Sergeant Rouse, you're now squad leader. Take over. That's it. The mission moves on just that fast because we practiced it and we did it. So, and without hiccup. So, because we talked about it and literally practiced it over and over and over again, operations continue in the military, whether Staff Sergeant McCabe is here or not. And I would argue that if you're not doing that for your business, you're doing your clients and your employees a disservice. So, just keep that in mind as you move on with your business and think about your estate planning for businesses.
Hey, Shawn, I'm going to share something that those listening may want to think about. Years ago, I had a client, and every January he wrote a letter to his wife,
Mm.
and it started with "I love you. If something should happen to me this year, here's what happened last year, and these are the steps you need to take." And unfortunately, I was number two on the list. Number one was his attorney. Call the attorney. Number two, call Marshall. My phone number was there. I mean, it was like, and some people might think that's morbid. I saw it as he loved his wife.
Oh man.
Lo and
That-
behold, this person was killed unexpectedly,
mm.
way too premature, but his wife got to step two and called me and told me. And I mean, it was like, wow, this person loved his family enough to be preemptive. Um, Morbid, maybe, but these things happen. So,
Oh, that's perfect. Yeah, if you love your family, your staff, and your clients, you gotta take care of them when you're not here.
exactly, exactly. So, speaking of being caring and charitable,
Ah, yes.
catch that segue?
Good
Uh,
job.
Charities, you can, if you have an estate tax, one of the best ways to get rid of it in my eyes, and Sean's as well, I know, is being charitable. There are so many organizations that could use your help. We hear quite frequently of extremely high net worth individuals, such as Bill Gates, Warren Buffett, who dedicate massive amounts of wealth going into charitable situations. One really easy one is what's referred to as a donor advised fund, or a DAF. Funding is very flexible, tax efficient. It's a charitable account that allows you to receive an immediate tax deduction, whether that would be on your 1040 if you're still alive, or your estate return if you're not here anymore, and then recommends grants to eligible charities over time. You can also name heirs as successors to the donor advised fund so they learn philanthropy and can still continue the family's philanthropic legacy. Uh, these have become extremely popular in the last few years, and Sean and I have used these as tax planning tools with our clients. And if there's a charitable trend, if you will, in your family, this is an excellent vehicle to do that. Of course, within your will or within your trust, you can name a specific charities that you would like to reward in some case whenever you're not here. And we strongly encourage you to do that. But remember, you need to document, just not talk about it across the dining room table during Thanksgiving dinner. So it has to be a little more specific than that.
Yeah, that's
You
important.
get health now.
Yeah, getting the documents in place. So I know I touched on this issue a little bit in talking about dependents, but the same holds true here. I mean, Health issues, again, gets into a lot of issues where we're not thinking about it until it's a problem. But the same holds true. Our adult children may still need help from time to time. When I say adult children, I'm talking our 18-year-olds all the way up to our 90-year-olds. And that help can be made a lot easier with just a simple HIPAA release form. You walk into a doctor's office, say, "Yep, I'm their healthcare surrogate. Here's my HIPAA release form. Please give me the information so I can help, guide and help my son or grandparent or parent work through this scenario." And then I'm not just talking about our adult children still living under our roof. I'm also talking about our bittersweet day when our parents become like our children and they begin to need our help. It's going to happen. We can call a doctor's office and request information, and if we have these docs, done. So, in general, if someone you care about becomes incapacitated and needs help both on the medical side and the financial side, this is where a designation of healthcare surrogate and Marshall touched on earlier, the durable power of attorney come into play. And I would say, even if you're married, a lot of people think they're married, it's the spouse that takes over. I would suggest that you have these documents as well, because when you walk into an ER, like Marshall said, I love you. I love the way you say this, Marshall. Doctors are going to doctor, and their job is to save lives. And, not that we don't want our spouse's life saved or anything like that, but the doctors are under no obligation other than their oath to do what they do. And they're under no obligation to communicate with anybody unless you have these documents in place. So again, it's important, kind of beating a dead horse on this one, but when health issues come up and you need to be able to be there to help somebody, it doesn't matter unless you have those documents.
Absolutely, Shawn. And now education. I'm going to speak more specifically in a specific area that we use here, and that's the 529 plans. And I hate it mentioning IRS code sections, but that's the code section. That's what they're called. And it provides a vehicle for what we refer to frequently as accelerated gifting. This is kind of a neat thing that under the gifting rules right now that are $19,000 per year, you could gift 5 years accelerate, 5 years on the front end. So you could immediately fund a 529 plan, 5 times 19,000. This year's giving, that's 95,000. You could front end load into the 529 plan. And as long as you stay alive for those 5 years, you, the donor, stay alive for those 5 years, it eats it up $19,000 per year. And as a result, there's no impact to your estate other than it keeps that money out of your estate. But you are able to get the money earning in a tax favorable environment for a child or a grandchild or great grandchild or a friend, whoever. Um, excuse me. So these provide excellent vehicles for you to put dollars away. In
Yeah, and
addition, within your will, you may set up some educational trusts inside of those. That too is an option. Shawn, you had a comment?
yeah, and that is a huge opportunity for grandparents or parents that do have or come into wealth a little later in life, and their kids are a little bit older, where you start looking at like Florida Prepaid or some other educational assistance programs where it feels a little too late to catch up, where you can front load the 529, accelerating your gifts in $94,000 or whatever the number was, is an incredible opportunity for you to catch up on that if you were behind saving for your kids' education. So I love these plans, Marshall. Good point.
Exactly.
All right, so those were the couple of planning topics that relate to estate planning. A lot of folks don't think about is estate planning. So hopefully that was helpful. Want to touch on the OB3, as I'm calling it now, and some of the basic changes from that legislation. And first off is the annual gift tax exclusion. Marshall touched on that. This year it's 19,000. Marshall, I don't know if you've seen any updates since we put this slide together, but I don't know that the legislation has come out with the 2026 numbers yet. But as soon as they come out, we'll let you guys know what those are. You haven't seen them yet, have you?
It usually comes out in October. So
Okay.
we're as of this recording date, we're probably 6 to 10 weeks ahead of the curve.
Gotcha. Okay. Makes sense. The 2025 lifetime exclusion amount, the total amount you could give without having to pay estate tax is 13.9 single and 27.98 married. Again, that's for 25. Like Marshall said, in 26, that goes to 15 million and then 30 million married. And I believe that's indexed for inflation. So we should see that it's made permanent. We should see that continue to increase. And just a sidebar from a planning perspective, 15 million is not hard and to hit for a lot of people, especially business owners. So you may be thinking, "Hey, I'm not there yet," or but if you start thinking about it and you think 15, 20 years from now, you may be in that category. So we want everybody to be aware of it. The generation skipping tax, transfer tax exclusion is tied right now to the gifting rules, but it's per individual for 2025. It's 13.99. 26 is 15 million. So that's synced up with the lifetime exclusion amounts. And then any time or anything above the exclusion amount is subject to 40% estate and gift tax. And that's for the generation skipping transfer tax as well. So 40% is huge. So that's why we bring this up, talk about it. If you're getting close to that category, there's some things that we can do to make sure we preserve those exclusion amounts for you and your spouse.
Sounds good, Shawn. I'll start wrapping up a little bit. So the main thing we look at on estate planning's implementation is to become familiar as you can with the basic rules. Shawn and I have hit the high points. Believe me, either one of us could probably do an hour dissertation on any one of the slides we put up here because we've seen it go through with various clients. Um, Consider annual gifting strategies using that $19,000 and, you know, super fund the 529 if you can. Titling is not only important, I'm going to say it's critical and frequently overlooked, especially beneficiaries, or if you're in second or marriages, or, you know, there's yours, mine, and ours. I mean, there's a lot of things that go into titling that are critical. And then, you know, we open an account and just kind of ignore it for years, but that could come back and haunt you when it comes down to death or disability time.
Yeah,
Choose-
Marshall, if I can jump in real quick, one
Yeah.
thing I've seen a lot is people either do it yourselfers or they do go see an attorney and they get a trust created, but they don't fund it.
Yep.
That means the trust is useless. So titling is huge. So if you do have an estate plan done, just throw the word, "Hey, is everything titled properly?" out to your advisor, and that will get the conversation started.
It's about as useful as an unbuckled seatbelt.
Indeed. You
Yeah,
got
we've
it.
got a seatbelt in the car, but hey, when you need it, you better have it buckled.
100%.
Uh, Another thing is to really choose your people wisely. Do you want the same people managing your money as managing your children? And I have to share a true story with you. I had a husband and wife sitting in. We were doing their planning for their estate, and the wife had just been extremely hesitant on meeting with the attorney and getting the documents drawn. And one of the things we've been saving for in their plan was a cruise. And the two of them were going on a cruise and leaving the children with the husband's mom. And so, you know, there's this hesitancy with the wife. And so the husband leans back and says, I love this. You do realize, honey, that if something should happen to the kids, the court may decide to make my mom their guardian. And if they do, they'll turn out just like me. And I swear she sat there with her cell phone and dialed right into the law firm I'd referred them to. I'm like, okay, if that's what it takes, that's awesome. But that's the way it could end up. So make sure that, you know, you got your people named properly and the information is communicated and updated regularly. We know lives are dynamic. So we don't have a real direct example here, but probate can cost you between, say, 1% and 3% of the value of the estate to get that administered. So having the trust, if you've got some things that you you think in your mind, do I want to pay somebody 3% to handle this? You probably don't, because that's taking it away from your heirs, and you can be proactive and keep those costs way down. But see a good and estate planning attorney for planning and drafting those legal documents. And as Shawn alluded to, we have a number of firms that we work with, and these are just outstanding men and women who do a wonderful job on the legal side of things.
Indeed, indeed. Marshall and I did a review of some of the more common OB3. So we touched on the impacts of estate planning today, but we did go through, in full and fair disclosure, we did not read the 11,000 page bill itself, but we have resources where we pulled through and reviewed what's most important to the majority of our clients. And it's still relevant. So we just wanted to give you a quick link. If you'll scan that QR code that's on your screen right now, that'll take you back to our YouTube channel, specifically to our review of the One Big Beautiful Bill Act, aka OB3. And just hopefully you can glean some little information out of that. Also, while you're there, if you would to like and subscribe, you'll get notified to anything we upload, as particularly related to today. We're going to post this out there, and if you're subscribed, you'll get notified there as well. So with that, as we wind down here, Marshall, I want to personally thank all of you all for watching and allowing Marshall and I to share a few estate planning tips with you. I generally hope today's presentation either has you asking yourself questions or ready to take action to get your plans in order. Know that Marshall, myself, and the rest of our team here want to help you in any way we can. So please don't hesitate to reach out. Before I turn it over to Marshall to close things up, I wanted to share a little something new we'll be doing on most of our presentations. And so, in case you missed it, Marcel and I do quarterly economic updates where we kind of talk about the market, the economy, and general direction of what's going on in the world of things. And you know us CPAs, and Marshall picks on me because I'm former military. We love acronyms. And we created a new acronym called the FPAC. Sounds fun, Marshall. What that stands for is the Financial Planning Action Quarterly. And that's kind of what prompted us to dig a little deeper. And then once we saw that it was Make a Will Month, it's the perfect time to do it. So last quarter, Q3 of 25, we actually issued our first Financial Planning Action Quarterly to anybody who's tuning in to encourage them to get their designation of healthcare surrogate. So one small piece of the estate planning package in place just to give a, hey, here's something that Marshall and I have seen over the quarter that we think is either interesting or we're seeing a lot of clients struggle with. So I'd suggest that if you're interested in just getting those cool nuggets, that sign in to our website, log in, and on the next slide, I'll show you or give you our link to our website. So Marshall, you can advance to that now. But you can connect in with us, sign up for our newsletter, sign up for our economic updates, or you can just visit us on www.mccabegunn.com, click the tabs for more, and then sign in for our newsletters. But my point is, we really like to encourage our clients and anybody who's tuning into us is to just take small amounts of action every chance they get to move their financial plans, and especially right now, their estate plans forward. So I just want to encourage you to continue to follow us and look at your estate plan. Marshall, I think that's about it for me. I'll turn it over to you.
I think that's about it, Shawn. I want to thank everyone for taking the time and listening in today. And if you know someone who would benefit from our presentation, as always, feel free to share it with your family and friends. But we thank you for joining us, and we look forward to meeting with you at some point in the future. So, again, thank you very much for attending. Take care.